This is one of those lawyers behaving badly. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Several times a year, I feature these cases where lawyers have just gone off the deep end. And that's pretty much the only thing I can conclude on this case because I've never seen one like it. I've seen things similar where people just drop the ball and maybe quit being a lawyer, but heavens to Betsy, this is really an odd case. In order to fully understand the case, I think probably the first thing we need to do is have you understand the way a relationship between an insured, an insurance company, the insurance company's employees, and the plaintiff in a lawsuit all work together. So here are the players in this case. The insurance company at issue here is a company by the name of Zurich Insurance. They're a fairly big commercial insurer, and they insure a lot of businesses with commercial general liability policies. And those policies provide for coverage for a wide variety of things, including, of course, negligence. We have an auto dealer over here who has been sued by a plaintiff for injuries. And the injuries are the result of a car accident. And as I understand it, the employee was driving a vehicle that was owned by the auto dealership, got into an accident with the plaintiff, and there were parties who sustained fairly severe injuries in that crash and needed lots of medical help. Now, the plaintiff did something smart here. He sued both the employee and the automobile dealership. Dealership is liable under a theory of vicarious liability. In other words, the employee was driving that vehicle in the course and scope of his employment for the auto dealer. He is the auto dealer's servant. That's an actual term under Missouri law. Because he is the master, he is responsible for the torts of his servant, the employee. And that doesn't excuse the employee from also being liable. It just means that in this case, there is a bit of a deeper pocket to go after. It's part of the law of master and servant. It dates way back into England times. And basically, in England, if you're the person who was your butler poured coffee on your guest and burned him, well, you, as the homeowner or the master of the house, were responsible for that. So it's pretty much the same way now. You're responsible for anything that's in the course and scope of an employee's duty, and those are the allegations that are made in the case. When the auto dealer gets sued, he turns it over to Zurich Insurance. And Zurich Insurance has an employee by the name of Petruska, who is an insurance lawyer. He basically defends the dealership and handles the claim against the dealership. He is employed by Zurich Insurance, but his fiduciary duty runs to the auto dealer, not to the employee, because the employee is not covered by this insurance. The dealership is covered for, the damages that arise out of the accident and injury, but the employee is not covered. This is something that I think most healthcare employees don't understand. The hospital has insurance, yes, but it's the hospital's insurance. It's not your insurance. They can, in fact, throw you under the bus if they want to. So that's something to keep in mind. But at any rate, back to this, Petruska is responsible for defending the claim brought by the plaintiff over here against this employee and this dealer. So, as I said, his fiduciary duty, his duty to protect, goes to the dealership. And then his duty to be decent opposing counsel to the plaintiff is just part of our legal system and legal process. Now, the attorney being disciplined is this Petruska fellow, and After they did a hearing, they concluded that he should be suspended indefinitely with no leave to apply for reinstatement for 3 years. So you're going to have to go find something else to do for 3 years, is essentially what that is. But the panel further recommended that the court stay the suspension and place Petruska on probation for 3 years. Well, Petruska loved that deal. He said, "Yeah, take it, sign me up. I'll do that deal." But the Office of Chief Disciplinary Counsel rejected it, and they contend that Petruska is ineligible. That's what the court finds, and they wind up essentially taking his license or putting it on suspension for a period of 3 years, and he can't apply to get it back for at least 3 years. So they say he violated a bunch of these rules. The court found that he violated Rules 1.2, which is scope of representation. Essentially, the client defines the goals of the representation, and the lawyer figures out what the strategy is going to be. Rule 4-1.3, which is the duty to keep the client informed. You have to tell them how things are going. You have to be diligent. You have to continue to operate on a daily basis, if necessary, in the case to make sure that the case gets handled properly. Rule 1.4, 4-1.4 says you have to communicate with the client. You have to make sure that you're talking with them and providing them updates and all that. Rule 3-3 is candor to the tribunal. You have to tell the truth to the court. You can't lie to the court. You can't misrepresent to the court. You can't shade the truth to the court. It will come back to haunt you. And the rule 8.4c is the misconduct rule. And what it says is you can't lie, cheat, deceive, anything like that. And if you do, that's misconduct and you can be punished for it. So after considering all of that, that's what they did. They suspended him with no leave to reapply. But what's important here is the procedural history as well as the actual history of the problem that led to this entire event. So Petruska was admitted to practice in 1995. So he's been doing this for about 30 years now. His license is currently in good standing, or at least it was before this opinion was written in March. Had no previous disciplinary history, meaning he hadn't come up on the Office of Chief Disciplinary Counsel's radar, and he was doing business as the law office of Craig A. Hansen. So I'm not really sure how that works, but I'm guessing that that is the captured law firm for Zurich Insurance Company. He was a chief trial attorney. That doesn't mean he's the boss over everybody. What it means is he is the primary decision maker in the cases that are assigned to him. So the law office would defend Zurich's insureds who were sued for claims covered by their insurance policies. As a chief trial attorney, Petruska handled mostly large catastrophic injury claims, and that's certainly true. Zurich has been known for handling what are called umbrella policies, which if the primary line of insurance doesn't cover you, you've got $1 million in general liability, and you've got an umbrella policy that covers everything from above 1 million to say 10 million. Those are the kinds of claims that Zurich often gets involved in. So they those claim professionals would normally control the final decision in settling the case, those people being the adjusters. So in an insurance company, you may have trial counsel who handle the actual doing of the trial, but then you also have adjusters who make decisions about the amount of money that needs to be paid. Now, the thing with adjusters is when the case first comes in, they set a reserve. And a reserve is the amount of money that they take out of long term investments and set aside to pay a claim. And the, the adjuster does well when he settles a case for less than the amount that he reserved. So, in a situation where the claims adjuster has reserved only $50,000, for example, if he settles the case for $90,000, he looks bad and it costs the insurance company money because anything that they save on this tends to wind up being labeled as a profit. Insurance company accounting is not like your average dime store or Quick Trip. The actual accounting for how they move money around is it's the kind of thing that makes people's heads swim. So I can't even begin to fathom how they do this. But generally speaking, the adjuster is the person whose purse strings that's the guy who can say yes, we'll settle for that amount, or no, we're not going to. So in this particular case, Zurich and its insured, an automobile dealership, were involved in a serious accident with a mother and her daughter. The injured parties sued the dealership and the employee. The Zurich adjuster supervising the case was an individual with whom Petruska had previously worked and found it difficult to work with. So he and the adjuster were clashing over the settlement value of the case. As the parties proceeded into depositions, Petruska had difficulty locating one of the employees. He's now a former employee. And to make a long story short, that winds up getting them sanctioned. And for whatever reason, he doesn't tell the insurance company that they've been sanctioned. And he continues to work with the plaintiff on the other side. And he says, we need to talk about settlement and that sort of thing. So, like I said, he didn't inform the claims department that they had filed a motion for sanction or that the circuit court had granted it. But during discovery, the plaintiffs produced a medical report that recommended surgery for one of the plaintiffs. In other words, he's been badly injured. He's going to need maybe knee reconstruction surgery or something like that, plus rehab. And he's not going to be able to do certain kinds of work that maybe he was training for. So the plaintiff's attorneys deposed the physician who testified consistently with this report. Petruska believed the assessment would likely increase the potential damage and resulting exposure for the insured. So he asked the adjuster to settle the case for the $120,000 that the plaintiffs had demanded. And Petruska emailed them, well, I should back up. In order to defeat that, what the adjuster said is, look, you go out and find us an expert physician who will say to the plaintiff, you're not hurt that bad, and here's our medical doctor who says you're not hurt that bad, you're not going to need surgery, or whatever it is that he might say. This is a common trick with insurance companies. They do this all the time. If you have a homeowner's claim and your roof is damaged, they send out an adjuster and the adjuster looks at it and says, yeah, it looks like you need to have your roof replaced. By the time he gets back to the home office and he says, yeah, this roof needs to be replaced, the person who's in charge of that, the actual adjuster on the claim, says, no, I don't think so. We're not going to replace it. And you wind up having to threaten Armageddon before you ever get a dime out of the insurance company. So it's not unusual for insurance companies to do this. But for whatever reason, and I'm still unable to figure out what he was doing, he told the plaintiffs that I have authority to offer $120,000 and I'm offering it. But he had no authority to do that. Now, they'd earlier told him they'd be willing to accept 120, and he told them I have the authority and I'm offering it, so they accepted. And as a result of that, he continued to go back to the adjuster and say, I need $120,000. And the adjuster kept saying, absolutely not going to happen. And the defendants, in addition to that, remember, if you look at that diagram that I had up there earlier, the client is actually is not the insurance company. They're just providing the money. The client is the automobile dealership, and the automobile dealership has to give consent to settle this, and they didn't do that. So the circuit court entered an order on November 7th of 2019 saying the cause is passed for settlement. So during the course of almost any civil case, you have certain dates where you have to go up and tell the judge where things are, what's going on, all of that. And as a result, they had to go up, and the case should have been ready for trial at this point. It wasn't, because Petruska didn't have an expert and he hadn't disclosed an expert. And instead of telling the court this, we're not ready for trial, or I need more time, or whatever, because he'd promised to pay a settlement to these folks, he told the court that the cause was passed for settlement. That was a misrepresentation. That's a violation of the Rule 3.3 that says you have to be candid with the tribunal, and he wasn't. So then he proceeds to go through a long period of shining the counsel on the other side, saying, I'm getting the runaround from the people at Zurich. We'll get you a check soon, as soon as we can, we'll get you a check. He got an updated W-9 form, and then he just kept going back to the adjuster and saying, we need more money. And the adjuster kept saying, get me an expert. It was a real runaround, I guess, but instead of doing the honorable thing and saying, I screwed this up, he kept telling the plaintiffs, I'm going to get you your money, I'm going to get you your money. At one point, he even sent a check, or he told the people that he was sending them a check by Federal Express, and the Federal Express check never came because he didn't put it in the envelope because there was no check. And so he basically said, well, maybe it's been stolen. We'll cancel that check and we'll issue a new one. He did a lot of different things to kind of delay, and it wasn't going over well with the plaintiffs. They were about to file a motion to enforce the judgment. And so, in order to sort of prevent that from happening, he went to the actual defendant, the automobile dealership, and he said, look, I need a check for $120,000 because we're having a problem with cash flow at Zurich, and I want to be able to make this work. And the the dealership called their attorney, and their attorney said, do not give them a check. That's why you buy insurance. The insurance company's got the duty to pay this, not you. About that time, somebody at Zurich figured out what was going on, and they fired Petruska, and Zurich wound up paying the plaintiffs $125,000. The $5,000 more was for the delays and the difficulties that they'd encountered. In addition to that, Petruska had fraudulently requested a check for an expert for the amount of the sanctions that had been imposed, and he said during his hearing that he did that because he didn't think that Zurich would cover the employee if that was, if for whatever reason they found out that he was not available for a deposition, which may or may not be true. I'm not really sure. But the interesting thing about that is Zurich had no duty to cover the employee. But by the same token, when you negotiate a settlement for everybody who's on the defense side, usually. And that's what Mr. Petruska was trying to do. I will give him credit for that. I don't give him credit for lying and being dishonest with everybody. So the Office of Chief Disciplinary Counsel basically charged him with violating all of these rules. And as a result, they found that he'd violated those rules. And what it came down to was the analysis really came down to what was the appropriate discipline. And almost all the Supreme Courts in the country use these ABA model rules or model standards. And there are two different standards, one for disbarment and one for uh, suspension. The disbarment standard says disbarment's generally appropriate when a lawyer with the intent to deceive the court makes a false statement, submits a false document, or improperly withholds material information and causes serious or potentially serious injury to the party. Well, that's exactly what happened here. 6.1.2, that's what Petruska wanted him to go on, says suspension is generally appropriate when a lawyer knows that a false statement or documents are being submitted to the court. So you see the difference there. One says the lawyer's doing the act, the other says the lawyer just knows about it and doesn't take corrective action. So the Supreme Court said, no, this generally falls within the scope of Rule 611, and as a result, we're going to suspend you with no leave to reapply for 3 years. I really do think that, he basically came in and said, I had marital problems, I was under stress, the dog bit me, the kids didn't like me, whatever. My coffee was cold when I went to Starbucks. All these different excuses for why he did this, but none of it explains the dishonesty. I can understand where you might make a mistake and get caught crosswise between your adjuster and the plaintiff, but what you do then is you make a clean breast of it. I think he was afraid of getting fired, and he thought he could kind of soft soap the adjuster into giving him the money that he needed. And indeed, at the end, the adjuster wound up giving him the money that they needed, but not because Petruska had done the right thing, but because he basically got caught with his pants down. So this is one of those cases where I think the court could easily have gone with the disbarment standard because there was potential injury to the client. There was serious injury to the insurance company. They definitely didn't deserve having to pay a settlement that their employee got them into. But here's the thing, because Petruska is their employee, they're vicariously liable for his conduct. And as a result, they had a duty to protect their insured, the automobile dealership, so they had to pay the settlement. In the end, Zurich did the right thing because Petruska did the wrong thing. Any questions? Put them in the emails or drop them in the comments down below. This was an interesting one, I hope.
That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.